I stand to speak on the Public Works Offer Back of and Compensation for Acquired Land Amendment Bill. I'd like to begin, Mr. Speaker, by thanking the honourable member, excuse me, Mr. Turoro Flavel, for his hard work on the issue, for the seriousness with which he has approached the issue, and for the excellent level of discussions that have taken place in regard to this bill at the Local Government and Environment Select Committee. Mr. Speaker, just to reflect on Te Ururua Flavel's final comment, which was that he hoped this, the consequence of this bill would be a review of the Public Works Act, perhaps I could turn that round slightly without causing offence and saying that in the event of the Public Works Act being reviewed, this could then be part of that review, because I think a review is probably going to be wider than just this issue. And I think we basically had good agreement on that in the committee. Mr. Speaker, National rightly supports this bill to supported this bill to Select Committee, as we felt it was important that the issues were debated. The Public Works Act was reviewed in 2001, but despite the noise it generated at the time, no changes were made. This is one of the reasons why, almost a decade on, it has been worth revisiting this debate. Mr. Flavel's bill has obliged people to consider the Public Works Act, and whilst the broad intentions of it are good, there are significant concerns associated with the bill as used and as drafted, particularly in the past, and the potential impact of its provisions. These concerns were pointed out in some of the 71 very sincere submissions we received and were again highlighted in the advice we received from Land Information New Zealand, the government department that administers this Act. This bill seeks to ensure that former owners of Māori or general land taken or acquired by the Crown for the purposes of a public work are given the first right of refusal to purchase that land where the Crown no longer requires it for the public work for which it was originally taken or acquired. And Mr. Speaker, if you have easily understood that sentence, I suggest you should do a cryptic crossword, or I suggest that one could do the cryptic crossword in the Manchester Guardian and find it a dolly. Basically, the situation is that, let's give an example, perhaps, that was brought before the, let's give an example that was brought before the committee by one of the submitters, where land is essentially bought for a purpose such as a runway. But then the runway moved into a different direction, and therefore the land was eventually used, say, to house cool stores at the airport. That was not the purpose for which the land was taken. And that basically is part of the argument that affects this whole thing. The bill as drafted would do this through amendments to Section 40 of the Public Works Act 1981. The bill would also provide for salarium payments to be made for loss of land or opportunities associated with its use where land was acquired or alienated for a public works purpose for which it was not actually used. Where the former owners of the land are deceased, the bill would pass these rights to be exercised by their descendants. Mr. Speaker, as we noted in the Select Committee report, it would appear that the bill's offer-back and salarium provisions are intended to apply retrospectively, and then we start into the major financial, practical and legal implications should this bill be enacted. The committee was advised that a number of previous Public Works Acts in New Zealand's history have all permitted land to be acquired for one use and then used for another if changes in use were in the public interest, and that this allowed the effective and efficient management of land for public works purposes. I dare say, Mr. Speaker, that the members of the House can begin to see the complications which creep into this well-intentioned provision. Provisions proposed in the bill could undermine and invalidate these historical changes of use. In effect, all land where the current use is different from the original public work would become surplus on enactment of this bill, requiring the investigation of this land, its offer back to former owners of successors, and they would have to be defined, irrespective of whether the land was acquired compulsorily or by voluntary agreement. This would be a most unfortunate, unintended consequence. Not only this, Mr. Speaker, but there's no central and easily searchable register of land acquisitions, transfer and disposals under the Act since it was first enacted in the 1870s. There are likely to be thousands possibly thousands upon thousands of properties held by the Crown or local authorities that are not currently used for their originally intended public work, but are still being used for a public work purpose. As such, if this bill were passed, it is likely that every Crown agency, local authority, state-owned enterprise and Crown Research Institute would have to make an initial assessment of all land under their control to establish whether the bill's requirements affected that land. And, Mr. Speaker, we were provided with copious illustrations by local authorities as to the detail involved in that. If any part of that land was not being used for the original work, a full offer-back investigation under Section 40 of the Act would be instigated. As one can imagine, Mr. Speaker, the resulting workload, it would be unduly burdensome and costly, especially as implementing the offer-back provisions of the current regime can take up to 12 months for a single property. There would also be impacts on the future use of land. Consider, for example, the situation in which the Crown currently has land or land acquired by local authorities for public works that is transferred or set apart for another public work. It's often considered more efficient and cost-effective to use land already in Crown or local authority ownership for a new public work rather than to acquire more private land. However, if this bill were to be implemented, there would be the likelihood that all land in this situation would have to first be offered back to the former owners or their successors, and then we come into the problem again of defining exactly what a former owner or successor is. The process of offering back and then reacquiring land sounds like a logistical nightmare, and indeed it would be. For a party and a government, or for a party leading a government that's about cutting red tape and simplifying and streamlining our resources, I would suggest, Mr. Speaker, that this bill is the opposite of what we would wish to achieve. And also, to create this degree of bureaucratic procedure was not, in my mind, the intention of the author of the bill. Aspects of this Act are being reviewed in Phase 2 of the RMA reforms anyway, which I look forward, as a member of the committee, to being involved in. This bill has been carefully considered by the Local Government and Environment Select Committee, and I take note of the very kind comments that Mr. Flavel made towards the seriousness that was given to this bill by the committee collectively and by individual members. And I can certainly say on behalf of the committee that it was a very interesting bill, and it certainly exercised our minds. And I stand by the committee report, which highlighted many of these difficulties and problems, which again I repeat were not anticipated by the author when it was introduced. National is opposing this bill. Thank you, Mr. Speaker.
The Honourable George Hawkins.